Hello everyone, welcome to Indian Current Affairs podcast channel. Today we are going to discussing some of very important MCQs related to Indian polity. Let's start the first question. Consider the following statements regarding the Attorney General of India. First statement: he is the highest law officer in the country and is appointed by the President on the recommendations of a three-member committee comprising of PM, Leader of Opposition and CJI. Second statement: one of the qualifications for being appointed as the Attorney General is that the person must have been a judge of a high court for at least 5 years, or an advocate of an high court for 10 years, or an eminent jurist in the opinion of the President. So which of the following statements regarding Attorney General of India is correct? So first of all, who is Attorney General? So for every person, if he need to be appeal in court or to represent himself in court, he need an advocate. Similarly, to represent Indian government in any court, so Indian government need an advocate. So that advocate is Attorney General. So Attorney General represent Indian government if any case is related to Indian government. So he is that person. So first of all, if you see the first statement, he is the highest law officer in the country. This is the correct statement. And is appointed by the President on the recommendation of Prime Minister and Cabinet Ministers, not by three-member committee. So this statement is wrong. So next, if you see the second statement, one of the qualifications for being appointed as the Attorney General is that the person must have been a judge of High Court for at least 5 years, or an advocate of a High Court for 10 years, or an eminent jurist in the opinion of the President. This statement is correct. To appoint as a Attorney General, so the qualifications need to be Attorney General are same as the qualification need to be a Supreme Court judge. So both have same qualifications. So these are the qualifications. He must be judge of a High Court for 5 years, or an advocate of High Court for 10 years, or eminent jurist in the opinion of the President. So any of the following conditions can qualify the person to become as an Attorney General of India. So next question, explanation. Recommendation by the Union Government. The Prime Minister and the Union Council of Ministers typically recommend a qualified candidate to the President. Qualifications. The candidate must meet certain qualifications. There should be a person qualified to be appointed a judge of the Supreme Court. As we already discussed, person who the same qualifications need to be appointed as a judge of a Supreme Court and Attorney General are same. Meaning they must have at least 5 years of experience as a judge of a High Court, or 10 years of experience as an advocate of a High Court, or be an eminent jurist in the opinion of the President. Appointment the President. Based on this recommendation, the President appoints the Attorney General. So next question. Third schedule of the Indian Constitution provides for forms of oaths or affirmations for whom among the following. So as we already know, third schedule contains forms of oaths or affirmations. Here they are asking whose oaths or affirmations are present in third schedule. So if you see the Union Ministers, the President of India, the judges of Supreme Court, Governor of a state. So to whom we have forms of oaths or affirmations? Answer to this one is we have Union Ministers and judges of Supreme Court are present in third schedule, but not President of India and Governor of State. The President of India and Vice President and Governor of States, their oaths are directly mentioned in the Constitution. They are not separate mentioned in third schedule. If you see the explanation, so answer to this one is 1 and 3. If you see the explanation, the third schedule of the Constitution of India contains the forms of oaths or affirmations for the following positions: Union Ministers, Members of Parliament, Judges of Supreme Court, Comptroller and Auditor General of India, Ministers for the States, Members of the State Legislature, and Judges of High Courts. So all their oaths are present in third schedule. And then if you see oaths mentioned outside third schedule in the Constitution, President of India. So Article 60 contains oaths of President of India. Oath administered by the Chief Justice of India or the senior most judge of a Supreme Court in the absence of CJI. Vice President of India is mentioned in Article 69. Both administered by the President of India or a person appointed by the President. Third one, governors of a state. Article 159 mentions their oath. Both administered by the Chief Justice of High Court or a judge of the High Court appointed by him. So next question. Which of the following statements is correct? As per the Constitution, the tenure of Rajya Sabha members is 6 years. Second statement, the minimum number of ministers in the Council of Ministers or the Centre must be 12. Third one, it is mandatory for the person to be an ordinary resident of the state to be eligible for governor's nomination to Legislative Assembly. Fourth one, there is no ground mentioned in the Constitution for the removal of the Vice President. So which of the following statement is correct? If you see the first one, as per the Constitution, here said the tenure of the Rajya Sabha members is 6 years. So if you see the tenure of the Rajya Sabha members is 6 years, but it is not mentioned in the Constitution. Instead, it is mentioned in the Representation of People Act 1951. So this statement is incorrect. So if you see the second one, the minimum number of ministers in the Council of Ministers or the Centre must be 12. So this statement again wrong, because here it is not centre, it is state. So the minimum number of ministers in the Council of Ministers at the state must be 12, not at centre. The maximum percentage of ministers is 15% of the MPs in case of centre, 15% of the MLAs in case of states. So maximum number of ministers are same in case of both centre and state level, but there is no minimum number of ministers in case of centre, but in case of states they are mentioned as 12. So this statement is also wrong, because it is not centre, it is state. If you see the third statement, it is mandatory for the person to be an ordinary resident of the state to be eligible for governor's nomination to the Legislative Assembly. If you observe carefully, it is not Legislative Assembly, it is Legislative Council, because governors don't nominate any person to the Legislative Assembly. So as we know, in case of bicameral in a state, governor nominates some members to the Legislative Council, so not to the Legislative Assembly. So no MLA is nominated by governor. So this statement is also wrong. If it is Legislative Council, here it is Legislative Council, then this statement is correct. Here it is Legislative Assembly, so this statement is wrong. So finally, there is no ground mentioned in the Constitution for the removal of the Vice President. This statement is correct. There is a mentioned how to remove Vice President, but there is no mention of the ground to remove the Vice President. So this statement is correct. As per the Constitution, the tenure of Rajya Sabha member is 6 years. So this statement is incorrect. The Constitution does not specifically mention the tenure of Rajya Sabha members. The Representation of the People Act 1951 provides that members of Rajya Sabha have a tenure of 6 years, with 1/3 of the members retiring every 2 years. The Rajya Sabha, however, is permanent body and is not subject to dissolution. Next, the minimum number of ministers in the Council of Ministers of this centre must be 12. This statement is incorrect. The Constitution does not specify a minimum number of ministers in the Union Council of Ministers. However, Article 164 of 1A of the Constitution requires that the state governments must have a minimum of 12 ministers. But this provision applies only to the states, not to the centre. Next, it is mandatory for the person to be ordinary resident of the state to be eligible for governor's nomination to the Legislative Council. So if it is council, then this statement is correct. Under Article 171 of the Indian Constitution, there is no explicit requirement in the Constitution itself that mandates a person to be an ordinary resident of the state for being nominated by the governor to the Legislative Council. However, Section 6 of 5 of the Representation of the People Act 1951 states that a person must be an elector of an assembly constituency in the state concerned to qualify for the being nominated to the Legislative Council. This could be interpreted as requiring as a form of residency, since being an elector typically implies residency in the state. There is no ground mentioned in the Constitution for the removal of the Vice President. This statement is correct. The Constitution does not provide specific grounds for the removal of the Vice President. The Vice President can be removed by resolution passed by a majority in the Rajya Sabha, followed by an agreement from the Lok Sabha, but no reasons or grounds are required to be specified. So next question. Consider the following statements. Statement 1. The governor of the states in India are mostly outsiders and do not belong to the state in which they had office. Second statement. This practice is mentioned in the constitution and was added to keep the governor free from local politics. So if you see, first statement is correct. The governors of the states in the India are mostly outsiders. So no state government, no state governor belongs to same state. He is from out of that state, from other states. So this statement is correct. This practice is mentioned in the constitution? No. This is not mentioned in constitution. It is just a practice. So it is not mentioned in the constitution. So that's why this one is wrong. But the reason is correct. To keep the governor free from local politics, we appoint governor from other states, not from same state. But it is not mentioned in the constitution. Next question. Which of the following are the discretionary powers of the governors in India? Special responsibility with respect to law and order in the state of Nagaland. Special responsibility for peace and ensuring the social and ecosystem advancement of different sections of the population of Sikkim. Declaring that no act of parliament shall apply in the respect of religious or social practice of the Mijos in the Mizoram. So which of the following are the discretionary powers of the governors in India? So as we know, governor get some more additional responsibility in some of northeastern states. So in which first statement, second statement are correct, but third one is wrong. So special responsibility with respect to the law and order in the state of Nagaland, correct. Special responsibility for peace and ensuring the social and economic advancement of different sections of the population of Sikkim, this is also correct. But here declaring that no act of parliament shall apply in respect of religious or social practices of the Mijos in the Mizoram, it is decided by that state legislature, so not by governor. So that's why this is the wrong statement. So 1 and 2 are correct, third one is wrong. If you see the explanation, under Article 371A of the Indian Constitution, the governor of Nagaland has special responsibilities for law and order in the state. This provision grants the governor certain discretionary powers to ensure that the special provisions for Nagaland are implemented effectively, particularly in maintaining peace and order. The governor of Sikkim has a special responsibility under Article 371F for overseeing the social and economical advancement of various sections of the population. This includes ensuring peace and addressing regional concerns unique to Sikkim. This power is not within the discretionary powers of the governor. Instead, this one about third one. So this provision is covered under Article 371G of the Indian Constitution. Article 371G allows the Mizoram Legislative Assembly to make laws concerning the applicability of parliamentary acts on religious or social practices of Mijos. The governor does not have the authority to unilaterally declare that no act of parliament shall apply. Such decisions are within the purview of the state legislature. So this is the end of today's class. Thank you very much for watching.